Right. So, thank you for joining us today. A little bit about the ICCP. The ICCP, or the Institute of Construction Claims Practitioners, is a professional members organization that recognizes those with skills, qualifications, and expertise in the professional management of construction claims. We have three primary objectives. First, to establish international professional standards for the management of claims. Second, to give recognition to those who have gained appropriate knowledge and expertise in this area. And third, to help and educate those who wish to gain experience in the management of claims. So why do we need another professional institute such as the ICCP? Well, construction claims have become a key part of the international construction industry. And many professionals from many different backgrounds, such as engineering, project management, law, etc., have somewhere along the way gained the right knowledge, skills, and experience to manage, prepare, and respond to claims. And those people deserve recognition within the industry. Until the ICCP was established, there was no institute that specifically recognized those who have the specialist knowledge, experience, and skills to be able to manage, prepare, and respond to claims to the highest level of professionalism. We want to support you in the best way we can. So in terms of strategic direction, the ICCP has an elected steering committee comprising of 5 elected fellows that you are now seeing on the screen, and the ICCP's executive officer and an elected president. The ICCP also has a small and friendly management team, which I'm part of, and we're here to answer any questions you have about the ICCP and our community. Right. On the topic of membership, here is a quick look at the levels we offer. For individual members who are already working with construction claims, we have 3 levels, each with their own set of requirements to be met in order to be eligible for membership. You can find the specific details on our website, instituteccp.com. I will share the contact details at the end of this little introduction. We also offer student and graduate memberships for those who are still studying towards a construction qualification or have recently graduated and are in the early stages of their careers. For companies who specialize in claims or have departments that specialize in claims, we also offer corporate membership. Right, so what is in it for you? Our members get plenty of benefits for being part of the ICCP community. We have a private members area that gives you access to a collection of resources that can help expand your knowledge on claims and the construction industry as a whole. There is also a library of practical templates that can save you time and help you refine your own work on claims. We also collaborate with industry experts to deliver monthly webinars like this one. And the ICCP members get 1 CPD hour for each and are issued CPD certificates at the end. Right. In addition to public webinars, we also offer ICCP Academy sessions to our members only. These are short, to-the-point sessions focusing on a practical claim subject. Last month, for those of you who attended, we had a ICCP Academy session on keeping a claims register, and a lot of members found it really engaging and useful. All of the webinars, including the ICCP Academy sessions, are recorded and put in the members area. So once you become a member, you gain access to that right away. We have partnered with 2 academic publishers to allow ICCP members to save on books. Additionally, there is a member-only discount on training courses by our partner Claims Class. Our monthly newsletter for members provides an overview of the latest ICCP news and beyond, keeping you informed of the latest developments in the industry. Right. We offer industry exposure in the form of a public members list, as well as the benefit of a logo and membership certificate so you can showcase your designation. As a member, you would also get access to a private LinkedIn group where our members can ask claims and contracts questions in a confidential setting and get advice from their fellow members. We also have the optional benefit of the Register of Claims Practitioners, which is a popular choice with our consultant members. Finally, we have an annual conference which takes place in September every year. It's free to attend for members, but also the recordings are available in the members area forever. So if you missed it this year, you can easily catch up. And now, if you want to know more about the application process or what the members area looks like, we have videos on this on our YouTube channel. All the details about ICCP membership are easily accessible on our website, www.instituteccp.com. If you have any follow-up questions to this very quick introduction, you can email me at paulina.ganeva@instituteccp.com, or alternatively, you can email our general email address, membership@instituteccp.com. Right, almost done. If you requested additional information when you register for this session, you will be getting an email in the next few days with our membership brochure and more details. I will put all the contact details in the chat for you if you want to make a note of them. I'm almost ready to hand over to Mark, who will talk today about claims under the KSA Civil Transactions Law. In terms of questions, there will be time at the end. If you have a question while he's talking, please put it in the Q&A box below, and he will answer it at the end of the session. Please use the chat box only if you want to discuss something with fellow attendees, and put questions in the Q&A box so that they don't get lost. Okay, and with that, I will hand over to Mark.
Thank you, Paulina. Let me just try and share my screen quickly. There we go. Why is it not? So thank you very much. I've seen a number of my fellow countrymen as attendees. I've also seen a number of familiar faces. And thank you for allowing me to speak and for joining this webinar series. This webinar series has been a long time in the making, and I've been punting this since we've been trying to get it off the ground since about March, April this year, and this was the only available time that I had. So, if you're a claims practitioner and you've been doing claims or been involved in claims in any part of the world other than KSA, my suggestion to you and my recommendation to you is to forget about what you have learnt or what you have done previously, because KSA is a different region. Things take place differently in terms of that. And prior to the current CTL, which is the Civil Transactions Law, it was a lot different. We are still busy. I've been involved with a lot of legacy matters that has transpired or arose prior to the CTL, and it is not an easy process. So, and I thought it would be good if I could demonstrate or share my experience with my fellow ICCP members in order to allow you the benefit of hindsight and the benefit of my experience within the actual region. So I will follow a 7-step process. So we first look at traditional construction claims. Then we'll just touch on what contracts in Islam looks for. And we'll also consider the Islamic custom in commercial transactions. And thereafter, we'll talk about the Civil Transaction Law, Royal Decree number M191, which was enacted in June, but came into effect in June 2024. It came into effect in December 2024. So it was pushed through very, very fast. And then we're going to look at matters of cause and effect under the CTL, and then contract ambiguity delay analysis. And this is purely under the KSA regime or KSA jurisdiction, and then my conclusions. So traditionally, if we've been working on claims for a long time and we're working in other jurisdictions, construction claims, normally in order to demonstrate the claim or to make your claim successful, there's got to be a causal link between what we call the event, and that event must arise out of the contract. It means the event that you rely upon there must be a contractual entitlement, and then you also need to then demonstrate cause and effect, and then establish the damages suffered. Now, the damages suffered primarily in jurisdictions other than the GCC would look will be based purely on the contract. There are some areas in other jurisdictions, like in terms of penalties, whether a DLD is a penalty and those type of things that will come into play. And then the remedy sought will also arise out of the actual contract. And there's a number of literature, and I mean, even on our ICCP website, there's a number of literature around what constitutes a good claim. My discussion today is not about what constitutes a good claim. My discussion today is all the more around what are the pitfalls and how we should go about demonstrating a claim or preparing a claim in the KSA region. So now contracts in Islam are different from contracts in the Western world. So under the contracts in Islam are written by three salient injunctions, and they basically prohibit interest, uncertainty in contract, and also speculation. Now, what it means is that normally under the Western jurisdictions, we talk about interpretation of contracts, and a lot of arguments are raised around interpretation. Whereas under contracts under Islam or Islamic jurisdictions, they tend to remove uncertainty and also tend to remove speculation. And then the purpose of that is that you eliminate exploitation in transactions. So what it means is that normally when I was in my first year of law school, it will tell you that a contract doesn't have to be fair. It must align to the law, but it doesn't have to be fair. In terms of contracts under Islamic jurisdictions, there should be, or there's normally or generally a concept of fairness around these contracts. And then also it looks at preventing unjustified enrichment. What it means is that your various formulas that you utilize in order to calculate disruption costs will not find a place in terms of contracts in Islam. And so it's a very different approach. Now, I'm not a scholar in Islamic law. I had to understand these various concepts when I was doing claims in Islamic jurisdictions. And so what I found is that especially in KSA, there's a lot of Western consulting houses and Western legal firms and Western contractors that are coming into the KSA and doing a lot of the work there, because there's a lot of work taking place in KSA. But they come with that same Western approach in how they deal with actual claims. And very quickly, there will be a rude awakening in terms of that. For example, if I look at a lot of the times guys will come and say, oh, but there is a time bar clause. Now, the argument is, does the time bar clause work? Is the time bar clause justified? So what we've often found is that what happens in the GCC, and especially in KSA up until today also, contractors do not do not follow the contract to the T. Whether they submit a notice in terms of a FIDIC terms contract is irrelevant. And coming into that region where I've worked mostly with, you had to put in your notice. If your notice is not in place, you could time bar a claim. This never worked in those actual jurisdictions. And you'll often find that on contracts, billion-dollar contracts, that there are no notices. And the reason being is that when you apply the law under Islamic law under contracts in the Islamic jurisdictions, the question that gets asked quite often is that, yes, so the contractor was late in submitting his notice, but Mr. Employer or Mr. Consultant, were you aware that there was a claim? And if there was an awareness of the claim, then you cannot rely on a time bar actual clause. So therefore, the contract coming into from a Western jurisdiction, coming into a Islamic jurisdiction, is very, very different. And you've got to align your thought processes in terms of that. So in commercial transactions, the Saudi Commercial Court has issued a law on the 17th of April 2020, which provides for conciliation and mediation. And the whole concept is around on dispute avoidance. And what you find is that although the Saudi Center of Arbitration is a long-standing and a well-standing foundation, it is very, very rare that you would elevate matters into arbitration. What I find happening in the region now, more is coming into place, is when they introduce FIDIC form or FIDIC type contracts, they have introducing now a standing DAB or DAAB, Dispute Avoidance and Adjudication Board. Adjudication hasn't taken off per se in the region, but there's a move in terms of that. Now, what I had to understand is that there's a long culture in Islamic jurisdictions of where they negotiate everything. I've been party to a situation where we have submitted the actual claim. We are well within our rights in terms of this claim, but the employer just says, I'm sorry, I'm not entertaining this. And also you got to understand that in these Islamic jurisdictions, there are certain key companies like your oil companies, your used government entities. They do not very easily accept the actual claim. And it doesn't matter how good you put this claim together. And the reason being is that they reject the claim not for the sake of being difficult. They reject the claim for the sake of trying to enter into conciliation and to mediate the actual matter. And that means that there should be when you come and do claims in the Saudi, especially in the Saudi region and also in the GCC region, it's got to be a paradigm shift from being aggressive after your claims to a more conciliation approach and a mediation approach. Because there's not one claim that I have been involved with in Saudi Arabia and currently involved with where I have not been asked to come to a conciliation meeting or mediation meeting or a meeting with the senior representative of the company. And at that point in time, you'll probably find that they will negotiate a settlement. So whilst it is a very different experience, I've learned quite a lot in terms of that, in terms of how to increase my negotiation skills. Therefore, it is, whilst there's a perception that dispute resolution doesn't work, it does work, but it takes a different form. There's more reliance on conciliation and mediation than what there is on adjudication and arbitration. That's not to say that arbitration doesn't take place. There's a number of arbitration matters, but what you'll find is that the matters that go to arbitration are more around, it's not around the claims, but it'll be more around the transactional side. So, for example, it'll be more around the formation of joint ventures, more around the commercial aspects of a contract, and there's less and less matters around disputes around actual claims. I believe, in my personal view, that whilst there's a huge amount of construction taking place in Saudi Arabia, we're probably about 2 to 3 years off from any dispute crystallizing. And there's two reasons for that. The first reason is that because it takes so long to get matters resolved, and the custom, if you look at in the past experience, these matters will get resolved towards the end of an actual contract. So, for example, I've been on matters where it ran for 2 years, and towards the end, so every month you put in your actual claim in terms of the contract, but towards the end of the contract, the parties will then say, let's continue, but towards the end of the contract, let's negotiate and talk about it. So it's a huge paradigm shift, and even though you do the right things in terms of the contract, by the time the contract lapses, now the parties will now sit around the table and start to negotiate. Given the current amount of works and projects taking place in Saudi Arabia, you'll find that there'll be an imbalance in power shift. So, for example, a company like Saudi Aramco, a company like NEOM, what they will do is they will say, look, we will wipe off your claims, remove your claims, but we'll give you additional work. And that's a type of conciliation and mediation that takes place. So when I came to Saudi Arabia, when I started in Saudi Arabia, I became very frustrated because this was totally different to what I'm used to. So I had to change the way I approach claims. Whilst I had to still not lose sight of what I was taught, that remains, but it's how you apply it and how you proceed to execute what is due to you. Then came the civil transaction law. So now you've got a history or a custom of where there was always a negotiation, and that always happened at the end of the actual the works. Then came in the civil transaction law, and the civil transaction law, in my view, there's lots of reasons why they brought about the civil transaction law, but in my view, because of the type of work and the number of work is taking place, they had to attract international contractors. And prior to the civil transaction law, companies were very skeptical in terms of getting into Saudi. And the civil transaction law gave a lot more comfort in terms of doing business in Saudi. So the civil transaction law, although there hasn't been a major shift away from what we term as Sharia law, Islamic law, the civil transaction law has basically codified it. It's put it in codes so that what happens is that when a matter goes to arbitration or goes to the courts enline the codes. prior to the codes, the courts had wide-reaching and far-reaching powers, and you'll find that it was the award was based on a certain person or person's perception of how they interpret the Sharia or Islamic law, whereas now they're governed by the civil transaction law. Although that the Islamic law hasn't fallen away. This is also very clear in Article 95, and what it says is that a contract that's signed between two parties is the contract. So it's very similar to the parole evidence rule. There cannot be any matters introduced to the contract unless it's agreed. However, what's very important to understand is that the contract must be consistent with good faith practices. So what it brings into question is this: is that does your subclause 20.1 and the FIDIC, where you have a time bar, is that termed good faith practices? The jury is out in terms of that, because on the one hand, it states that if there's a time bar clause, you must abide or must stick to that time bar clause. But on the other hand, it says, but it's got to be consistent, or it's got to be applied in a manner with good faith practices. And therefore, that introduction of good faith practices in the clause takes it back into the Islamic culture or custom, which says that even if I don't submit my actual notice, it may not be enforceable. There's a number of cases in KSA where on some instances it was enforced, and other instances was not enforced. So those are matters that's got to be considered. And then what's also important is that the Article 95 subclause 2, it says that the contract will be binding on the parties in terms of provision. So in terms of what is set out in the contract, that's binding. But then it also talks about legal provisions, customs, and the nature of the contract. So custom is very important. So custom automatically doesn't take away the rights of Sharia law. So custom is very, very important in terms of that when you deal with the actual contract. You cannot disregard custom, and therefore, although a contract might state that you will be a time bar clause, you got to consider whether that time bar clause will actually stand in terms of custom. And the jury is out on that because, again, there are some cases where that has been some cases where the judgments came out in favor of upholding the time bar clauses. In other cases, the judgment came out in saying you cannot enforce a time bar clause when the employer you are aware of the event, and now you cannot plead that you cannot plead ignorance. And if you do plead ignorance on that basis, it would then argue the fact that you will be unjustly enriching yourself. On the other hand, Mr. Contractor, if you knew that there was a time bar clause, why did you not apply it? And the difficulty there is that you will find that contractors have been operating in Saudi Arabia for, let's say, the past 10, 15 plus years. They've never ever had to submit a notice. It was never a requirement because when it went into dispute, they would negotiate it out. And what I was contracted to a major tier 1 contract in Saudi Arabia, and one of my biggest challenges was to get the sites to apply the contract to the word in terms of Article 95. And what I've tried to do was say, guys, we've got to err on the side of the contract. And yes, as long as we follow the actual contract, then we'll be okay. And there are times, it was one matter where for 3 years, there was no notice being issued. And the difficulty with this one was that the contractor was undertaking some works for a major employer organization in Saudi Arabia. Now, that employer organization in Saudi Arabia brought in a lot of expats to run the claims division. And that expats, they ran the claims division, or they ran it strictly in terms of the Western principles, that they would say, if you haven't submitted your notice, you are being time barred. So they stuck to the rule of the contract. Whereas the contractor, because he was not used to, or he was not required to comply with the contract, he found it very, very difficult. And when I was brought in at the stage to assist the contractor, we was 3 years without actually notices. We were being time barred left, right, and center. The employer organization was not interested in the claims. What we then did was I said, let's submit the claims, even if there's a time bar. And we then argued we brought on board a legal firm to assist us with drafting the notices and to draft the claim. And we raised an argument around the Sharia law argument. And what then happened was that the parties in the employer organization invited the contractor to negotiation. And yes, whilst we never received the full amount, we created that opportunity to negotiate. Then what's also very important is under Civil Transaction Law Article 128. Now, those of us that have been working in the Western jurisdictions, we know that concurrency is a hot topic in terms of delay, assessing delays and quantifying delays. Under Article 128, the law is very clear. It says that you got to, if you're producing a claim, you've got to identify, or you've got to ring fence your culpable delays against what the other party is culpable for. So that means that there's an apportionment of the contract. Contract then understands, and contract speaks to concurrency. But the problem here is that the contracts don't normally. What happens is the contracts will say, if there's a concurrent delay if there's a delay which the contract is responsible, then it's entitled to zero time. What we've done in that instance, we argue success and say, look, that goes against the Article 128, because Article 128 specifically talks about apportionment. You cannot introduce a clause which now says that if there is an overlapping delay, that we lose everything. So what is not very clear in this, although it's clear in terms of apportionment, it doesn't tell you how to treat concurrency. Must it be through concurrency? Again, the argument, it must be through concurrency, or must be an overlap. Now, the way I interpret this Article 128 is it means that I've got to apportion. So if it's through concurrency, it means I won't be entitled to any time. But if it's overlapping periods, you're now being entitled to claim for money and time in terms of that. So without it being properly expressed in the contract, it does create the opportunity for ambiguity to actually creep in. So it's very important that and you will still find that the contracts are written in a manner that doesn't talk to concurrency, or it talks to the absolute concurrency portion. It's very important that you understand, and if you are involved in drafting contracts, to expand upon this Article 128. And we've always asked, and I will always recommend that you ask a law firm to assist you in terms that the law firm that is well versed in matters of Islamic law, in order to, and also in construction law, in order to make sure that you, when you draft a contract, it doesn't contravene Article 128, but at the same time, it should create clarity around Article 128. So the difference between doing cause and effect under Western a civil transaction law and Islamic law and non-Islamic law is that the only difference is that you got to culpability, you've got to establish liability. You got to establish, what am I liable for? What is my liability in this contract? And then your remedy should look at the apportionment. And that's the only difference. And a lot of times you will find that contractors struggle in terms of this, or employee organization. And what we find more often now is a lot of the times on most of the projects here, PMOs, project management offices. So you office, yes. So what we find is that companies like for example, Hill International, DeSimone will get involved in those type of work as well. Most of these PMOs are coming from a Western culture. And the Western culture is that they're coming to into this country is that they will apply the contract as they are used to applying the contract, without understanding what's under the civil transaction law. And I can say 9.9 out of 10 times when I've had discussions with the PMOs on behalf of the contractors, you will find that my biggest discussion is around, guys, you're penalizing us for concurrency, but you're not considering what is sitting in the CTL. And when we've introduced that fact, when we showed him the fact, and we showed him the article, then they had to go back to the drawing board and to relook at it. And what we've also found is that ambiguity in the contract. So Article 128 is very clear, but you still find it in the contract where they will specify, and it will state you've contracted the delay analysis method is a TIA, a time impact analysis method. Now, the time impact analysis method cannot be used to establish culpability nor to apportion. Why? Because the time impact analysis is a prospective. It looks ahead. It doesn't look at the areas of delay. It tells you this is my likely impact. Now there are two sides to this coin. The first side is that I would reject it at the outset if I'm acting from a contract perspective, and the second one is that it could aid the contractor. So what you find is that the contractors tend to be liking the TIA because it creates a exaggerated entitlement, and the purpose for that exaggerated entitlement is it allows them a bigger window to negotiate down. So that is a cause, I believe, in today in Saudi of what was one of the causes of my biggest stresses, because the contract is saying one thing in under the main conditions, and under the specification that says in this, it tells you TIA. And contractors has been working in Saudi, planners who working in Saudi for a long time will always go for TIA. And the reason being is that they will exaggerate their entitlement and then go into a negotiation. And these are where the ambiguity sits. So time impact analysis, I can guarantee you go into any contract in Saudi, you will find that they use a time impact analysis, and exactly for the reasons why I've set out, because it creates an exact entitlement and then allows the parties to enter negotiation. The contractor starts negotiation at a higher level, and then it comes down to what he believes it would be beneficial to him. And then also the absolute treatment concurrent delays. This is another ambiguity in the contract. So when you are drafting contracts, you've got to consider these two. These are the two main factors. And talking from a claims perspective, these are the two main elements or main areas of concern for me. Yes, if you are a lawyer, you will look at there are a number of other areas that will be of concern. But for the purposes of today's discussion, I believe that these two areas, if you're going to go work in Saudi, these are the two areas which you really need to consider and understand. So just to give you an example of a TIA. So a TIA, you got an as built, you got you will build your works, or you will bring up your program, your as planned program, up to the point in time when the event occurs. And when that delay event occurs, you will then prepare fragments. Now, what needs to happen is that whilst the TIA just looks at progress at the point in time, any analysis under the civil transaction law needs to not only look at the progress, but needs to also understand what is the extent of the progress. So when you do your updates on a month-to-month basis, you basically got to do a as planned versus as built on a month-to-month basis. And the reason for that is that you can then demonstrate whether there is concurrency or coupled delay, and how you're going to apportion it. So when the time you get to the point of the delay, you'll know exactly what is your culpability, or what is your liability in terms of what happened to that, and the employee's liability. Then what happens is you will then put in place your fragnet. Now, the TIA stands only at the start of the fragnet. It doesn't look at the end of the fragnet. It only stands at the start of the fragnet, and then what it then does is it then you then schedule the program to see what the forecast completion date is. So the difference under the CTL is that you cannot just do that. Like I said, everything from the start of the project on a month-to-month basis, you got to come do a as planned versus as built. You got to compare where you're at to where you should have been. And then once you've done that, you've then got to assess any capability, and then apportion the capability between yourself and the employer. But what's also important is, and this should become practice, once you insert the fragment, now the fragment is a difficult situation, because yes, your fragment will give you a forecast, but what the CTL says is that you cannot unjustly enrich yourself. So therefore, you've got to then move beyond the TIA and move through the actual delay period. So, for example, if you have a fragment that shows an adjusted completion date, which is exaggerated, you would then have to pull it back as you execute the work. And that is one of the reasons why the TIA doesn't work in KSA in terms of the CTL. Yes, it works to serve certain purposes, but it doesn't work to serve or to talk to the contract. And what happens then is that during so when you go through, as you put in your fragment, your claim will not arise normally at the date of your fragment. What will happen is that there will be a wait and see. A wait and see up until the delay ceases to see what is the actual extent of the actual what is the actual extent of the delay. Now, some people will argue the fact if you use the Western civilization jurisdiction, you would argue the fact that you cannot apply a wait and see. However, in Saudi, it seems that the contract does allow you to apply a wait and see. Therefore, the time frames which a contract sets out for evaluating claims is never, ever stuck to. So, example, there's a matter I was involved in. It was a roads project and tunnels. The delay extended for a period of 18 months. And during that 18 months, generally, if you're working in a Western jurisdiction, you'll be able to under a FIDIC form contract, you'll be able to submit your claim on a month-to-month basis. Whilst the contract was doing its claims on a month-to-month basis, the PMO said, no, we're not going to assess it because we cannot establish what your actual delay is. Although you could always argue the fact that look, at that point in time, in that specific month, there was a delay. The issue is that it narrows the view in terms of apportionment. And the key thing is that, and again, turns on how do you apportion, how do you test, how do you treat concurrency. So therefore, it's very important that you do sit and talk to a lawyer in Saudi that is familiar with the CTL and how to write it in. Because if you don't do that, you're going to end up, contracts are sitting, claims going 2, 3, 4 years, haven't been resolved because either events are ongoing or there's just a position from the employer side that, look, I'm not going to consider any claim. I'm not going to even look at any claim. I'm going to negotiate. And once a party decides to negotiate, there's nothing you can do as a claims consultant. All you can do is that you can prepare the claim to as best as you possibly can. And keeping in mind also, in order to stick to the requirements of the CTL, you've also got to ensure that the remaining work to completion, it is realistic. There's no duration changes. And I mean, we've been in the industry for a long time, and we've all seen how people tend to crash the program. Now, I've seen instances on a very famous project, and I cannot mention the name, in Saudi Arabia, where there was the project had an initial duration of 2 years. Additional work orders were issued under the variation orders, additional work. The resources extended from 1,000, 2,000 people to around 20,000 people on this project. And what the employee then said was, listen, we're not going to extend the completion date. You're going to do this within the same time frame. And contractors trying to appease the employee because they want to get the work, they want to keep the work, they agreed. But what it then did was the loss and expense increased. They could not extend the duration. So now you create a hamburger effect where you got all this work in the center and you can't move the actual project. When we were asked to come and assess it, we actually established that the contract, that the work should have been delayed by at least 14 to 18 months. And because the agreement was that they couldn't shift the completion date, what we then said was, in terms of the CTL, you cannot unjustly enrich yourself. So that means that there would have been a claim for additional costs or prolongation or thickening costs claim. And they tried to fight it, but then what we then said was, look, guys, we agreed that we're not going to extend the actual time frame, but we must be realistic. We started at about 2,000 people. We're currently sitting at 15,000 people. Therefore, there is a thickening cost. Now, if you don't award that thickening cost claim, then it means that you are violating the CTL, and there is an element of unjust enrichment involved there. But again, although the arguments are actually sound, the reasoning is sound, still goes into negotiation, and the negotiation can take anything. Although the law says you gotta only allow 30 days for conciliation and mediation at maximum, the parties will always extend it at actual period. Because the reason being is that they don't want to go into arbitration. They don't want to go into the next level, and they try to push as hard as they can in terms of that. So those are some of the aspects that I've been exposed to. So in conclusion, if you are a contracts manager or contract administrator or involved in drafting contracts, don't apply that same copy and paste of contractual clauses. I've seen this often, and I've seen how it has failed. We tend to think that a one size fits all. You may get away with it for a certain amount of times, but when you're doing work in the region, it's not going to help you. It's not going to come. It's not going to work, because those contractual clauses are meaningless if you don't consider them against the CTL and consider them against custom. And in order to understand custom, you need to get a good Islamic lawyer on your side in order to understand custom. And then a robust contract administration focus. You'll be surprised, and I mean, we've been talking about this at ICCP, and in your careers, your professional careers, you will always understand documentation. The issue in KSA is that because of the custom and because the CTL is still fairly new, there's never been a requirement or reliance on getting the documentation and administration in place. So you'll find it's a lot less there. You'll find that contracts will run, mega multi-billion-dollar contracts will run, and there's no documentation. And one of the things that I had to be thinking about the team we had in KSA was we had to recreate what has transpired, recreate documentation. And that is it's a time-consuming process. And then also be prepared to negotiate. But and how do you prepare yourself to negotiate? You prepare claims, you prepare claim for a tribunal adjudication. That is what I've learned works. I had to do a lot of training and development in the region in order to get the people to shift their focus from business as usual prior to the CTO as to the new way of actually doing business. And what you find is that contractors seem to believe that they don't want to trigger the dispute resolution clause until it's too late. Given the complex nature of doing contracts in KSA, the dispute resolution clauses, you should trigger it very early. And the reason being is because the parties tend to want to negotiate in KSA. And if you don't trigger your dispute resolution clause early enough, that means that you're going to wait much longer. We have a matter where the contract was the employee took over the actual works, and they still never triggered the dispute resolution clauses. They still try to negotiate. They still try to try and the concept is that yes, we don't want to upset or offend the employer. But the issue is that if you don't do that, you'll end up with huge losses. I mean, there are lots of companies in Saudi Arabia that have gone under because of issues around the payments and the dispute resolution process. And what we're finding is the more Western contracting firms coming into Saudi Arabia, they got a lot more aggressive. The approach is a lot more. The approach is a lot more. So what you do is you need to trigger the dispute resolution clause early enough in the contract. And you, by doing that, you become less aggressive, and you create an environment where you can negotiate, you can talk, and I found that parties are open to talking, and yes, with any negotiation, a party will stand in the view, an employee will always stand, his stance will always be, I'm not prepared to pay you, and the contractor will always try to say, okay, how can we best resolve this issue? 9 out of 10 times is either through additional work. Or they will negotiate some sort of payment, and that payment is to prevent an undue hardship, and when you raise your claim document, it's around undue hardship, it's around unjust enrichment and stuff like that. That's the wording that you potentially use. You've got to use a lot more softer wording. I mean, I came from aggressive. I was very aggressive. People that know me in the claims environment will know that I was a very aggressive claims consultant. I go after the money and I make sure I actually get it. I had to learn patience. I had to learn how to be a more soft approach. I had to hone my negotiating skills, my conciliation skills, my mediation skills. Even though I'm a registered mediator, I had to hone that skills because in Africa we got a saying is African time. But African time has nothing to do with Saudi time. Things happen at their own pace. But things do happen. But the key thing is that you cannot go with the same mindset. You need to understand the custom, and you need to understand how to align your claims process not only to the contract, but also to the CTL. Thank you very much. I think I said a mouthful. I trust it was of interest to everybody. And I see I got 7 questions. Let's just go to the 7 questions.
Thank you, Mark. That was really interesting. I'm really glad we managed to schedule this session because it was very highly requested, and I think it will be really useful. And it was really useful. We do have 7 questions.
Yes.
Would you like me to read them out to you and then you answer, or would you like to read them out and answer? How do you want to do this?
If you can read it out, I'll appreciate it. I can make my actual notes.
Yeah. Okay.
Yeah.
So the first question is, you stated that disruption claims do not work under Islamic law. Can you explain more?
So I'm not saying that disruption claims do not work. It is the disruption claims under normal jurisdictions is very difficult to actually prove. It becomes a lot more difficult under the Islamic law because now you've got to apportion it. And we all know Islamic claims. We all know that disruption claims either follow a specific formula. It's not about factual, it's not about actual cost and losses. So if you can establish what your actual cost and losses are, yes, it will work. But if you can apply formula like the Hudson or Emden formula, that's not going to work because it doesn't give you a true or actual loss. It's a hypothetical loss, and on that basis, what it means is that you could be enriching yourself unjustly at the expense of the employer. So therefore, it's a lot difficult. It doesn't say it doesn't work. It's a lot more difficult to prove under Islamic contract law. Thank you.
Thank you. Next question: how binding is the conciliation and mediation?
So what I have found in the region is that people's word is honor. If someone says that this is what we agree, they will agree to it. So they don't need a third party to enforce that conciliation mediation, and it's all because of the customers of the people. And like I said, the underlying principles of Islamic contract law is that there must be an actual balanced playing field. So what you'll find is that when there is a conciliation or mediation process taking place, the parties more often than not, and in my experience, they've always agreed, and it was by binding. It might take a bit long to put it into writing, something like that, but I have found that conciliation mediation works well in Saudi Arabia and KSA, and when they go through the process, they deem to be binding upon themselves. Thank you.
Considering prolongation entitlement, does the approach of having to wait to resolve claims towards the end of the project not leave contractors exposed financially?
Yes, it does, and it has. And you'll find that a lot of contractors have actually struggled. But what they do is then they always keep the door open to talk to them, and they say, let's do a goodwill or good faith payment. That might not be what you would want to have, and that is why it's important that when you do your claims process, your claims process must follow your monthly reporting process. So every month, you'll say, Mr. Employer, I've actually lost this much money this month because of A, B, and C. So your claims process becomes a lot more robust than what would normally is. It's got to, so when you go to that meetings, you can say, guys, this is my actual issue. And keeping in mind, again, based on the customer I found, is that when you can present that argument to the employer and put it in sufficient detail, more often than not, you'll come to an agreement at that point in time. But the problem comes in when we use these, what we've used to, like the TIA, and we use Emden Hudson formula. The argument is always, but guys, we do not understand where you got this value from. Because keeping in mind, there's a hierarchical structure in KSA, more so in KSA. So the person you could be dealing with is not the person who's going to give you the answer. He's got to take that to his boss, and his boss take to his boss. And therefore, the information you provide must be sufficient to allow that person to be able to sell that to his boss. And therefore, the approach is that you've got to have robust claims on a month-to-month basis and identify your losses or your entitlement on a month-to-month basis, and then take it through.
Yeah. Next, we have a comment, a question. I think the idea of bringing good faith into the agreement, I believe, is something that can go a long way towards eliminating disputes. Yes,
I agree. I think we have a lot to learn about this principle about the good faith in the contracts, and also how we deal with the contracts, how we execute contracts. My experience in jurisdictions outside of KSA, is that we always try to see how we can do one over on the other party. But we as in KSA and the GCC regions, they try to bring in a level balance, a playing field, and that is by a reliance on the good faith clauses. Thank you.
Which principle from the civil law is time impact analysis not recommended?
Apportionment. You got to identify your own delays capability. TIA cannot do that. In effect, TIA cannot establish concurrency.
How practically is concurrency supported by the Saudi law?
It's written into the law, so it's been enforced on a day-to-day basis. And you'll find that when you submit your claim, most times that when you use TIA, you don't do concurrency assessment, your claims will get rejected at the outset.
What Saudi law says? What does Saudi law say for force majeure or pandemic cause of delays?
So given the new CTL, there is a provision for force majeure. So it is covered in terms of that to an extent. But again, I would urge you to get a lawyer involved that understands the Saudi legal system to draft those actual contracts and the clauses of the contracts.
You stated that interest is not paid under Islamic law, but if the payment is delayed, how to claim compensation for the delayed payment?
You claim what you lost, and if you let's for argument's sake say that you have got a bond or you've taken out a loan to buy certain things. If you can demonstrate that loan is built in, interest built into the actual loan, that's your actual loss, but you can't make a profit of it. So, for example, you can't. So, if you got to repay the bank 10,000 riyals, you can't now say I want 10,000 riyals plus on interest, so you pay me late. It doesn't work that way under that law. So, unless you're being charged interest for whatever you borrowed to keep yourself going, and it's built into what your repayments are, then it's fine. So, and that's the actual difference here. Unless the contract says that is a 5% handling fee, that is allowed. But you cannot charge interest because of late payments.
Thank you. We have 3 more open questions and 3 minutes, so let's see if we can manage them. Are the time bar clauses enforceable under the new civil transactional law if they're stipulated in the contract between the parties?
As I stated, there is the CTL states that the wording in the contract is a contract, but then again, it argues the fact that you got to also consider custom. So if there was a custom in Saudi that time clauses were not enforceable, it all depends on your legal team taking the matter to court. There are cases where it has been upheld, the time bar clause has been upheld, and there are cases where the time bar clause has been rejected. It all depends on the circumstances. My advice is don't rely on the time bar clause not being upheld. Work strictly according to the contract, because that is the governing article in the CTL.
Thank you. I think the next one is a comment. My understanding that the principle of any claim is what is actually incurred fairly despite of the time bar clauses.
That's correct.
Okay. Can the mediation and adjudication be internationally enforceable? I think so.
Now, adjudication and mediation can be enforced internationally unless there is an agreement to that effect. It's only arbitration, international arbitration. Adjudication hasn't rolled out properly in the region, but I've seen an upswing in it, but it cannot be enforced in terms of the arbitral rule can be enforced. It cannot be enforced in terms of that internationally. Thank you. Contra preferentum rule.
Yeah, that's the last question. Is the contra preferentum rule available under the CTL?
That contra preferentum rule, it's a very again, it talks about if there's ambiguity in the contract, the parties have sat and have negotiated this actual clause. We've tried to argue the contra preferentum rule where we said, look, the TIA doesn't agree with the actual contract. The problem with that is that they're gonna have to amend the actual contract, which will be highly unlikely. It allows you to either to try and fight it through the claim process. But yes, to avoid that, I've not had experience where the contra preferentum rule was challenged, and the matter was challenged on that basis. But yeah, it's a difficult one. My advice is that that you make sure at the outset that your contract is not ambiguity in the contract. There's a last question before I got to leave to join the meeting really. Is
Yeah.
adjudication decision. Now, you first have got to go from adjudication to arbitration, and then the arbitration gets enforced. And adjudication cannot be enforced through arbitration. It's got to be overturned by way of arbitration, and then you can seek enforcement, providing that the parties are signatories to it.
Thank you very much. Okay, we have to finish it here as Mark has another meeting. Thanks everyone for joining us today, for asking questions and for being really good listeners. Thank you, Mark, for delivering this talk. I think it was super useful. We will share the recording and the member CPD certificates in the next 2 weeks. And if you have any follow-up questions on this topic, just email me and I will forward them to Mark to answer. Okay?
Thank you very much.
Thank you.
Bye-bye.
Bye.